Mr. Knox.
My lords, my lady, I just wanted to show you one other passage, or a couple of set of passages from the full court, the Constitutional Court's decision. If I could ask you please to go to page 1380, paragraph 216. Beginning another aspect of the right to due process. As I mentioned, the appellants raised the point before the Constitutional Court that their right to due process, or their rights under Section 16 of the Constitution, or the Charter of Rights, were infringed by the having of the hearing in public. And the Court of Appeal, the full court dealt with that briefly. Another aspect of the right to due process protected by the Constitution, which is somehow relevant to the case being advanced by the claimants, is the right to a public hearing. They go on to set out subsection 3, and then in the next paragraph, subsection 4, para 218. In the case of the MACMA, no specific provision is made that the taking of evidence from persons in Jamaica on behalf of the requesting state should be in public or private. There's no requirement in the relevant statutory regime for the proceeding for the taking of the evidence of the claimants should be conducted in chambers or in private, as the claimants are contending it should be. Also, there is no evidence that the Kingdom's evidence has requested the taking of evidence to be in private, as it could have done, pursuant to MACMA. In the absence of all these special provisions, as the procedure to be used in the taking of evidence, Mr. Justice Campbell had a discretion to deal with the hearing in private, as can be seen from the relevant constitutional provisions in Section 16, subsection 4. However, he opted for an open court hearing, in keeping with the provisions of the Constitution that as a general rule, all proceedings of any court should be held in public. This is in keeping with an existing common law rule, and we, of course, adopt that. The Constitutional Court, we say, is quite right about that. And then, finally, dropping down to 223, in seeking to establish a basis for hearing in camera, the claimants, through submissions of their counsel rather than through any evidence, have put forward the contention that the hearing in chambers would be necessary for their protection. The point was made that to expose them to giving evidence in open court would expose them to danger, or was likely to expose them to danger of reprisal, since they'd be testifying in respect of persons who are charged for a criminal offence. And the court goes on to reject that. And then finally, one can drop down a few pages to 1386.
Before you do that, Mr. Knox, Lord
Yes.
It has a question for you.
My lord.
As I understand it, Mr. Knox, there was no appeal from the decision of the Constitutional Court.
No.
I also right to understand that you take no point about the fact that it's already been decided, this issue, by the Constitutional Court, and you say that it's open for the same issue to be relitigated in another proceeding.
Well, my lord, it's a nice point. I don't think I can go so far as to say, and I don't have to say that the point isn't open, my learned friend. But I simply say the Constitutional Court got it right. My lord, my learned friend, I don't think would be entitled to say that she is right on the Constitution, but so far as she can attack the judgment on other grounds, my lords, I don't take the point that it's not open to her in these separate proceedings to take the same point which was on which, in fact, she lost in the constitutional proceedings.
Thank you.
In this regard, Mr. Knox, I note that the appellant in paragraph 1, of their case say it's an appeal from concurrent decisions of the Supreme Court of the Court of Appeal. It seems to me that's not right.
Strictly, no. No, it's only from the Court of Appeal's decision, not from the full court's decision.
Yes, thank you.
My lords, I wouldn't want, however, I mean, if your lordships took the view that actually it's just plumb wrong that there's any jurisdiction, my lords, I wouldn't particularly want to be in a position of saying, well, it's bad luck for the appellants because they haven't appealed the full court's decision. The answer to that might well be they could be given leave to appeal that particular point if they needed it. But the issue is the same.
Would there have been an appeal from the full court to the Court of Appeal?
My lords, I am not able to say if it would have been to the Court of I think it would be to the Court of Appeal, but in any event, whether or not it was to the Court of Appeal or directed to your lordships, it could still filter its way through to the Privy Council in any event by one or the other route.
But I have it at the back of my mind that there was an appeal and it was withdrawn. But
That's right.
Perhaps in due course, Miss Robinson can help us in relation.
Yes. But my lord, it's not a point which we specifically take, but we just say the full court got it completely right anyway, and the reasoning should be followed. My lords, I think I was going to go to page para 234.
Yes.
Sorry, 235. The issue of hearing in chambers was raised before Mr. Justice Campbell, who heard submissions, refused the application. This conveys the impression that he had not seen any basis as a matter of law or fact on which to exercise his discretion to hold the matter in private. The refusal of the learned judge to exercise his discretion in favour of a hearing in chambers would give rise to a question as to whether he had acted properly as a matter of law. This would be a matter to be addressed by the Court of Appeal, and not one that falls for determination in this court. So the full court say, well, we'll leave over any question of wrongful exercise of discretion to the Court of Appeal in these proceedings, and so they don't take that matter any further. My lords, if I can now turn to the judge's judgment, which was written after this decision by the full court, which you can find at page 695, I think. Sorry, not 695, 34. MS 34. And
this is the full version of the judge's reasons given after he'd had the benefit of the judgment of the full court.
My lords, yes. My lords, what had happened is these proceedings had gone to sleep. And I think my clients applied to strike them out. But eventually they were resuscitated, and so as to allow for the appeal to go ahead to the Court of Appeal. And for the purpose of that appeal, the judge then provided a full written judgment.
Thank you.
And my lords, I'm taking it now from paragraph 36 on page 36. This is the first point I want to draw to your attention, because I submit it answers one of my learned friend's points. At the beginning of 36, Mr. Knight QC denies that there's any practice with which he is familiar where depositions are taken from potential witnesses in open court. I think every day. I think it happens every day in the coroner's court and at preliminary inquiries, to name two such places. And my lords, that's important, because here's, if I can put it this way, the local judge saying, this is just not true. It happens the whole time. Statements are taken from potential witnesses in open court. And my lords, of course, the preliminary inquiry method, of course, now we don't have it all in the UK, but in Jamaica, it's still, as my lords, you'll be familiar, it's flourishing. It's used in relation to see whether there's a case to go for indictment or not. And witnesses come along, and if there's simply no case, then the matter's not sent up to the Crown Court or the equivalent of Crown Court. So it's a commonplace that witnesses come along and say what they say happened about the offence. And there would be a similarity between this, the type of position in this case and in the preliminary inquiry. Namely, there would be a charge, an identified charge, which the witnesses would know about and which the accused would know about. But that, I submit, is no reason why a deposition can't be taken in open court without a prior statement being made. And likewise, under MACMA. The procedure is not at all, in my submission, different. It's quite similar. The next passage I'd like to go to is on the next page, page 37, where the judge in paragraph 38 gives his conclusion. He gives later reasons. I think there should be a public hearing in this matter. The court was told that the criminal investigation undertaken by the Dutch had its origin in the machinations of a political rival, who should not be able to get political mileage out of having these witnesses testify in open court. I cannot agree with the submission insofar as it suggests that a public hearing would foster some Machiavellian aim of a political rival. The rival may very well be embarrassed at the end of the day. An open court will end speculation and put to rest unfounded allegations, if any, and give the lie and visibility, I suppose, the lie to the visibility of those of whatever ilk, if any, who fostered such allegations. In my submission, that's a perfectly sensible conclusion, bearing in mind everything is already in the public domain in any event. And then paragraph 39, these public officials are not charged with any offence. My lords, this gives you an idea of how the case was being put, because I haven't been able to find the argument run by my learned friend to the effect that, oh, well, they may very well be charged in future. He's saying in terms, they're not charged with an offence. The term persons of interest, whatever it means, was not used by the requesting state, but emerged in the hearing in the submission of counsel, Mrs. Stewart. Witnesses are called to court every day. They are persons who may or may not advance the case they're called to support. Some have very little to tell, some have a lot. It's their answers to the court that will determine their value as a witness. A less than open court runs the risk of losing public confidence. In this polarized circumstance that counsel has alluded to, the court must open itself to the unimpeded glare of the media and the public at large. And again, my lords, I submit, bearing in mind the nature of the allegations and the nature of the publicity that already existed, one has only to ask this question. Supposing this was held in private, what would Trafigura think about that? And what would the public think about that? My lords, I just note in parentheses, it's not been suggested that Trafigura is supporting or indeed wanted this hearing to be held in private. And then dropping down to the next page, paragraph 41, there are occasions when the open justice, must be principle, may not be the best course when on reflection the administration of justice is better served by departure from that principle, even when the matter falls outside of the constitutional exceptions provided for by section 16.4 of the Constitution. The point there being section 16.4 provides specific exceptions to the open justice principle in section 16.3, but Mr. Justice Campbell, like the Court of Appeal, said the common law exceptions might be wider. And then paragraph 42. Counsel for the defendants argued that since this was not a trial and no civil rights or obligations were involved, the open justice principle is inapplicable. I find that a strange argument when counsel was also taking issue that his client's constitutional rights were contravened. And he then goes on to discuss the meaning of court or authority in the Constitution, which I won't for the moment go to because I'll argue it later. And then paragraph 44, in considering, on page 39, in considering the exercise of the court's discretion, the nature of the matter looms large. It concerns a criminal investigation of bribery of a Jamaican public official. The witnesses are public officials. Witnesses are aware of the questions to be asked. As public officials, 4 of the witnesses have had their hands on the principal instrument of policy and constitute persons who, along with others, are charged with the general direction, control, and government of Jamaica. To my mind, the more pressing question should be, why should they not be required to answer in an open court which provides access to the people they are sworn to serve? Why not? Now, that, I think, is a passage which the Court of Appeal says the judge may have gone too far on. My lords, I respectfully submit it's not an entirely reasonable thing when one considers the alternative, because the problem with the open justice principle is you've got, you either have to have A, open justice and everyone sees it, or B, secrecy. And sometimes it's not necessarily, sometimes one might say, well, they're both pretty unpalatable. But in a circumstance like this, I submit para 44, secrecy would have been unthinkable. And then para 45, from the submission of counsel, it's acknowledged there's considerable interest on the part of the public to know the questions and answers in this matter. Also there, my lords, I submit that's a perfectly proper thing for the judge to have held, bearing in mind the stage at which, or rather, the amount of publicity already that had been attracted to this. In Hodgson, Lord Wolfe speaks of the considerable interest of the media to know. It is therefore important for this court to weigh the conflicting public interests involved. Those interests involve the need to protect the administration of justice, recognising and protecting the freedom of the press, and the right of the public to be informed about matters of national importance. It seems to me that where the investigation is shown to be concerned with issues in the public sphere, that will tilt the scales in favour of a public hearing. And I submit that's unimpeachable. It's plainly right. The matter is not a private one. The legal entity being investigated is incorporated abroad. The business Trafigura is involved in isn't private. The question as to whether there is substance to the suspicion of Dutch prosecutors, as to whether or not a Jamaican official has been bribed, is important, whatever the direction the investigation takes. It will serve to dispel rumour and arm the public with facts. In a country where many persons are reluctant to assist the police in their investigation of crime, it will be a salutary move. on behalf of these public officials to demonstrate to the populace at large the necessity of cooperation. And then finally, paragraph 46, the last sentence, last two sentences on page 14. With respect, this is talking about, was there anything really pointing the other way? With respect, nothing was raised before me to demonstrate why these public officials should be treated in this matter in their private capacity. The contention that potential witnesses' evidence are not taken in open court fails the practice of the coroner's court in preliminary examinations. So, my lords, I submit that was a perfectly sensible judgment and well within the judge's discretion, assuming he had it. And the only exception made to that, and my lords, it doesn't really matter for my purposes, is what the Court of Appeal said. And I will just take you to the relevant passage in the Court of Appeal's judgment, which you can find at page 91. I hope, paragraph 74. Yes, he begins at paragraph 74. He asks the question, the ultimate question, is whether, given these considerations, the appellants have made good their alternative submission that the judge's exercise of his discretion was fatally flawed. And he then, in the next paragraph, Mr. President Morrison says, paragraph 75, page 92, I can say at once that, had I to do it afresh, I might have given less weight to factors relating to the appellant's status. Since the citizens' just their status does not entitle to special consideration, they're equally entitled to the same fair consideration as any other citizen. But this is, of course, as Hadmore makes clear, hardly a decisive factor, and this court must consider the matter as a whole, assessing all relevant factors together. And then the Court of Appeal goes on to say, taking that into account, there is no basis for interfering with the judge's decision. Now, my lords, if I can now just turn to the arguments, and I hope I won't have to take too long over them. My lords, I should have shown you, but I will do so now. Well, the first question is, did the judge have a discretion to hold the hearing in public? My submission is plainly yes. In particular, 2 points I just want to show you in the record. And the first is a point which has already been picked up on, but I think it is worth emphasizing. And that is at page 174, or I think, yes, the 8th supplementary letter of request, beginning at page 174, which is sent after the refusal of the witnesses to cooperate at Mr. Knight's offices. You'll see the assistance that's required on page 174, assistance requested, and you'll see this is how it's put in the 8th letter, request for judicial summons of witnesses. So at this point, the Dutch if I may put it this way, the Netherlands are firming up a bit. They are not just going to have a nice friendly interview at Mr. Knight's offices. They want a judicial summons of witness, and they request, quote, the judge of the Supreme Court or resident magistrate to order the above-mentioned witnesses to attend the proceeding and to give evidence, or to produce any document or other articles at that proceeding. And then the next page, 175, the 9th supplementary letter of request. The request you will see is that on page 176, after identifying the witnesses, B, it is requested that witnesses give evidence on oath or affirmation. In my submission, there's plainly a power to do that. And then C, the evidence would not be prevented from being given. The evidence could be given in court in the Netherlands. And then D, most importantly, we wish the evidence to be taken by a hearing conducted by a judge in court. We would very much like to have representatives from the Rijkskirche and the Public Prosecutor's Office President. And then E, no special requirements concerning the manner in which this evidence should be taken other than the evidence is given under oath or affirmation. And my lords, I submit, and this is my submission, this was plainly a request which they were entitled to make, to have it in court and therefore in open court. My lords, the other document I'd like to show you before I go to my legal arguments is at page 18 of the MS numbers. This is the order made ex parte by Mr. Justice Anderson on the 17th of November 2010 upon the DPP's fixed date claim form. And you'll see what the order is. It is ordered that Mr. Norton Hinds and so forth appear before a judge of the Supreme Court during the period to give evidence on oath. Now, my lords, the reason I emphasize that is when you look at that order, one would automatically think, well, i.e. in court. But my learned friend's submission is that when it says that, it doesn't mean, or it couldn't at least mean, judge of the Supreme Court. But in my submission, just looking at this order, one gets an idea of the fancifulness of the construction of the Act. The judge of the Supreme Court refers to someone of the status of judge of the Supreme Court, but not actually acting as a judge of the Supreme Court when taking the evidence. That cannot have been the intention of the Act, and it's quite useful just to look at a document which repeats the wording of the Act to see if it could possibly have been so. I submit obviously not. So with that, I now turn to the legal analysis. And my lords, I submit the starting point is the treaty. I say there's no doubt actually as to what the relevant words mean in this statute. But if I can just ask you briefly to go to page 858. And this, my lords, is the treaty. It is common ground. This, my lords, is the treaty which prompted the passing of MACMA. The International Drug Control Conventions, UN treaty, and the relevant page is at page 890, which provides for mutual assistance. The foot of the page, MS 890, Article 7, mutual legal assistance. The parties shall afford one another, pursuant to this article, the widest, I emphasize that, the widest measure of mutual legal assistance in investigations, prosecutions, and judicial proceedings in relation to criminal offences established in accordance with Article 3.1. Well, I simply emphasize that because it is obviously the purpose of the MACMA. And if there's any doubt about it, one can see it from this treaty, that the widest assistance be given in order to combat the problem of international crime. In fact, the Netherlands' requests, as I think you will have seen from our cases, were made pursuant to a later treaty concerned with the Convention Against International Organised Crime, which one can see, but I don't propose to take you to, at page, I think, 895. I might have got a wrong reference there, but anyway, it's pursuant to a different treaty. But it's virtually identical wording. And then the other relevant provision in this treaty is paragraph 2 of Article 7, mutual legal assistance to be afforded in accordance with this article may be requested for any of the following purposes. And you'll see it's in pretty similar terms to the way the Act is phrased. And then dropping down to page 892, paragraph 12 of Article 7, a request shall be executed in accordance with the domestic law of the requested party, and to the extent not contrary to the domestic law of the requested party, and where possible, in accordance with the procedures specified in the request. So in other words, the requesting party, this is the whole purpose of this, is the requesting party has a considerable amount of power, subject only to local law, to make whatever requests it wants. My lords, then, I say, therefore, it is wrong to adopt a narrow construction of the Act. You construe it in the event there's any doubt about it, in the light of the manifest purpose which is expressed in this treaty. Now, my lords, turning to the Act itself.
Can I just ask Mr. Knox?
Yes.
You've been referring us to the provisions of the Narcotics Treaty, which was responsible for the passing of MACMA initially.
Yes.
We're actually concerned with its use subsequently in relation to the Convention Against Transnational Organised Crime. Do we
Yes.
find corresponding provisions?
Yes, my lord. I thought I had the right reference in my notes, but it's in my case, in our case, and
Yes.
I
think it's 918. The treaties of 895.
Yes, and I think my lord. There certainly is identical, a virtually identical provision. It may be at 909 or 918. But my lady, I think I'm very grateful. I think it's 918.
Yes, grateful. Thank you.
Which I think has a very slightly different form of wording, which is even tougher. It's Article 18 on 918.
Thank you very much.
Yes, where the phrasing there is mutual legal assistance shall be afforded to the fullest extent possible.
Yes.
If that's different from widest measure. But anyway, the idea is the same.
Thank you.
My lords, turning to the Act itself, Section 15 is the starting point, page 734. In Section 15.1, assistance may be provided to a foreign state on request in accordance with this part. Assistance provided shall be in response to respective investigations and proceedings in relation to a criminal matter, and such assistance may be provided as aforesaid. And then B is the relative to the foreign state which makes request for the purposes only of the criminal law enforcement authorities in that state, and B only if criminal proceedings have been instituted or if there is reasonable cause to believe that an offence in respect of which such proceedings could be instituted has been or is likely to be committed. And then the nature of the assistance is then set out in subparagraph 3, including examination, taking of witnesses, production of documents, and really quite a lot of arrangements that can be made. So effectively, a lot of this covers an enormous amount of assistance that can be provided. For instance, seizing property and so on and so forth, intercepting communications. It's a very wide set of assistance that can be provided. The definition of proceedings, my lords, is at page 724. I should just show you that. What is referred to there in section 1, I think. Criminal proceeding in relation to an offence means A, a trial of a person for the offence, B, any proceeding to determine whether any person should be tried for an offence, and so forth. Now, my lords, what I say about section 15, reverting to section 15, is that there is no suggestion in section 15 itself that there should be any distinction drawn between proceedings where, or rather investigations where proceedings, between the taking of evidence where proceedings are already on foot and the taking of evidence for the purpose of a criminal proceedings. Nothing in section 15 says that there is to be some sort of difference. And in particular, section 15.2, subsection B, lumps together the notion of criminal proceedings having been instituted, together with the case of there being a reasonable cause to believe an offence has been committed. The next section, so I say, first of all, no distinction is drawn in the governing section. The next relevant section is 20, subject to the provisions of this Act, where a request is made to Jamaica for A, the taking of evidence, or B, the production of documents other than judicial records, or other articles, the central authority may in its discretion in writing authorise the taking of the evidence, and so forth. And then 2, where the central authority authorises the taking of evidence or production of documents or other articles under subsection 1, a judge of the Supreme Court or a resident magistrate, appropriately capitalised letters, A, in the case of the request for the taking of evidence, may take the evidence on oath of each witness appearing before the judge or resident magistrate to give evidence in relation to the matter, and shall cause any evidence so taken to be put in writing and certified so taken, and 2, cause the writing so certified to be sent to the central authority. And then in relation to documents, may, in the case of a request for production of documents or other articles, require such production, and shall send to the central authority any articles so produced, or any documents or copies thereof, and so on. And then subsection 3, the judge of the Supreme Court or the resident magistrate conducting a proceeding, I emphasize a proceeding under subsection 2, may, subject to 22, order any person to attend the proceedings and to give evidence or produce any documents, and then may permit the foreign state to do various things, and so on and so forth. Now, my lords, I submit 2 things from this. I submit it is quite plain from the use of the capitalized letters, the judge of the Supreme Court, the resident magistrate, it's plain from those words themselves that this is talking about the judge or the resident magistrate in the capacity as a judge of the court, not in some private capacity or some amorphous, unknown capacity. It's plainly speaking of a judge in capacity. If it was otherwise, one might have expected to see there a reference to a person of the status of a judge or a person of the status of a resident magistrate, but you wouldn't have that form of wording. Second, it is quite plain from these sections that the judge has a power to order certain things. But it'd be nonsense to talk about a judge having a power to order things if there wasn't anything he could do to follow up on his orders. That is to say, by committing for contempt of court. So the notion of this judge having a power to order, in my submission, necessarily involves the notion that he is sitting as a judge of the court with the powers of the court, not as some sort of person who has no particular power to make any, or he may have a power to order, but he can't do anything with the order if it's disobeyed. And thirdly, what I say about this section is it is plainly applying to any type of proceeding. It's not just limited, for instance, to the taking of evidence in support of existing criminal proceedings. It is applying equally to the taking of evidence to see if there is a case. And, my lords, that in my submission makes sense because, of course, it is not necessarily going to be the case that in every foreign jurisdiction that you'll have the same type of system, the common law system, as we have. There may well be a civil law system where prosecutors themselves do the investigating to a much greater extent than they would under the English or the common law system. So, my lords, my submission is, and this really is the heart of my submissions, this section is plainly giving the judge, or this section is plainly giving the court a power to do these things. That being the case, it must be right that the hearing can take place in open court. My lords, my learned friend relies on section 19, page 737. Subject to the provisions of this Act, requests to Jamaica shall be executed in accordance with the relevant laws in force in Jamaica and the procedures applicable under those laws. Where a request contains particulars of a procedure to be followed in the execution of a request, those procedures shall be followed to the extent possible under the relevant laws. My lords, I say there's absolutely nothing in the laws of Jamaica, in the common law of Jamaica, or in any statutory law, which excludes this type of hearing being made heard in open court. None at all. My lords, my learned friend has referred to the Justice of the Peace Act, I think at page 791. Section 34, or 35 more precisely. The relevant section begins, the relevant provisions begin at section 34 on page 791, which deal with preliminary inquiries. And that's quite a long section, but I don't need to look at that. Really, it's section 35 on page 793. The room or building in which such justice or justices shall take examinations and statement, as aforesaid, shall not be deemed an open court for that purpose, and it shall be lawful for such justice or justices in his or their discretion to order that no person shall have access to or remain in such room or building without the consent or permission of such justice or justices, if it appear to him or them that the ends of justice will be best answered by doing so. Now, my lords, I make 2 points as to this. First of all, this is not a general law which applies right across Jamaica. It's a specific provision in relation to preliminary inquiries, and it doesn't therefore apply to MACMA. Second, when you look at section 35, although it says it is not to be deemed an open court for a particular purpose, nonetheless, the default position is plainly that the evidence is to be taken in open court, because it continues after the semicolon, and it shall be lawful for the justices in his or their discretion to order that no person shall have access. In other words, it is open to the justices to prevent people entering, but if they don't do so, then people can enter. So I submit you don't get very much out of this in any event. And likewise, with the other statutes my learned friend mentioned, they're all just specific to the type of case they're dealing with, the Extradition Act and so on and so forth. But there's no common law principle in my submission which requires the gathering of evidence in circumstances like this be taken in private, nor is there any statute. And finally, my lord, section 24 of the Act, that's of MACMA, in my submission plainly presupposes, I think this is page 740, plainly is the provision relating to confidentiality. I've given a bad reference. It's page 744. Where assistance is provided to a foreign state in relation to the provision of information or evidence, the central authority may, subject to subsection 2, require that such information or evidence be kept confidential in accordance with such conditions as the central authority it may specify. Subsection 1 shall not apply in any case where the information or evidence is required for the purpose of any criminal proceedings in the foreign state. My lords, what I submit one gets from that is that it is presupposing that the hearing, of any type of hearing, in relation to a criminal proceeding can be heard in public. It's not saying it must be, but the premise of section 24 is that the hearing can be heard in public, and that the DPP, however, notwithstanding the fact it's been, but the DPP can hear it in private as well, or can require it to be heard in private. But the premise is that it can be heard open. So, my lords, that's what I say on the question of whether there's a discretion. My learned friend says that the nature of this type of hearing is such as to take it outside the open justice principle, because it is merely an investigatory hearing. In my submission, whether or not the open justice principle applies doesn't actually have any bearing on whether or not there is a discretion to hear in public. If there's a discretion to hear in public, it doesn't matter whether the open justice principle applies. But, my lords, that may be too narrow an answer, because I accept that both the judge and the Court of Appeal proceeded on the premise that broadly the open justice principle did apply. So I'll deal with the open justice principle in any event. And I'll first deal with the open justice principle. And, my lords, I submit it is right that the open justice principle should apply to this type of proceeding for the following reasons. First, a judge who is conducting the hearing will be exercising the typical judicial functions and will have wide powers in doing so, in particular to require witnesses to answer questions and to commit them for contempt of court. And that will apply not only to asking questions, but also producing documents. You'll recall, my lord, section 20B, I think, extends the powers to the production of documents. In doing so, the judge will be performing his typical judicial functions of ensuring witnesses answer the questions that they're asked and that the procedures that are followed are fair. And, for instance, that they will not incriminate themselves unfairly and so forth, and make sure that they're aware of the right to the privilege against self-incrimination. And therefore, as the judge is conducting a hearing with considerable powers over the witnesses and those appearing in front of him, the traditional justification for the open justice principle applies, namely, the desirability of the scrutiny of the conduct of the hearing by the judge. And for that, my lords, we rely on the relatively recent case of Kuja, which is at page 1192. And the relevant paragraph is paragraph 12. My lords, if I can just ask you to read paragraph 12 to yourselves. It's very familiar stuff. But the really important point is paragraph 13. And my lords, the essential point is the value of public scrutiny as a guarantor of the quality of justice, and also the significance, if anything, is increased in an age which attaches growing importance to the public accountability of public officers and institutions, and to the availability of information about the performance of their functions. And I submit it would be unthinkable, actually, if a hearing like this couldn't be heard in public. If that's what my learned friend's submission comes to. I submit, of course, it can and indeed should be heard in public because of the wide powers the judge has. My lords, the second reason I say that the open justice principle applies in this case is that the judge, in carrying out his functions, is doing so on behalf of the state of Jamaica pursuant to a treaty obligation. So both Jamaica and, in this case, the Netherlands, have an interest in seeing that he conducts the hearing properly. And that applies, of course, to the accused as well. And what would Trafigura say if all this was heard in secret? Third, in my submission, although the judge, of course, I accept, doesn't decide the case or indeed provide a summing up to a jury, the evidence that's going to be obtained at the hearing and to be used by the foreign state will enable it to decide whether or not to bring a charge against the accused. And indeed, it may then be used against the accused once it's been obtained. And my lords, you'll recall that in the Netherlands' ninth letter of request, they said the evidence that we're obtaining will be used or could be used in the Dutch courts. So the rights of the parties, in this case the prosecutor and Trafigura, are likely to be affected by the way the judge conducts the hearing. The fourth point we make is that it has never been held that mere witnesses have a special right to privacy. For instance, at a preliminary inquiry, there's no line of authority to that effect. And fifthly, the accused's position in a MACMA case is analogous to that of an accused at a preliminary inquiry, as I've previously mentioned. And this is the important point, when there is an identified charge and evidence is being taken in a formal setting, overseen by the judge, to see if a case exists and to make sure the questioning is done fairly. And my lords, I submit that's at the other end of the spectrum from what you might call the Cliff Richard case, where, as it were, the police are tipped off, or the entire public is tipped off about the fact an investigation is taking place, and you see helicopters flying over the individual's home. It is quite the opposite from that. Now, my learned friend has quite rightly referred to the ZXC case. I'd just like to make one or two points about that. That's Lord Justice Simon's judgment she showed you this morning. My lords, that case concerned the wrongful leaking of a confidential letter of request to Bloomberg's. That's basically what happened. And as a result of that, a story was published in one of Bloomberg's publications. And that story revealed that the claimant in that case was under investigation pursuant to the letters of request. Now, the letters of request in that case were confidential, and that was a breach of confidence. And that was the complaint made by the claimant against Bloomberg's. Bloomberg's ran various arguments saying, well, nothing wrong with that. And they lost, not necessarily terribly surprisingly. They lost before the judge and they lost before the Court of Appeal. And one can well understand that because the letters themselves were confidential in the first place. Secondly, one can see at the argument that at a stage where merely there is a confidential letter and there is simply an investigation and no more than that, one can see the argument for saying that an accused has a reasonable expectation of privacy. And that was what the case turned on. One can see that. And so, my lords, I say that ZXC is on a very different set of facts. We contrast that with the present case. First of all, the fact of an investigation is well known in advance. And this is all over the newspapers anyway, well before the Dutch even make their request. And I showed you that before, but the reference is at page 130, I think, 130 onwards in the record. Second, in this case, it had gone beyond the confidential letter stage. A claim had been instituted by the DPP, a hearing, and Mr. Justice Anderson had made his hearing, his order rather, that there be a hearing, which obviously everyone would know about. So the hearing's known about. And thirdly, what was an issue here is when you have a hearing, which everyone knows about, to take evidence from certain identified individuals, should it be in public or in private? Now, that was not the issue in the ZXC case. And no doubt, my lords, the open justice principle may be subject to qualification if there are good reasons. But really, what this case really comes down to is there were no good reasons for departing from the open justice principle on the facts of this particular case as they were put to the judge. My lords, briefly dealing with the Constitution, we deal with this in our written case, but if I can just ask you to look at the Constitution, I think this is at page 1049. Yes, 1049, MS 1049. Section 16(1), protection of the right to due process in relation to criminal offences, and then subsection 2 relates to civil rights and so forth. And then subsection 3, all proceedings of every court and proceedings relating to the determination of the existence or extent of a person's civil rights or obligations before any court or other authority, including the announcement of the decision of the court or authority, shall be held in public. And then subsection 4 provides for certain exceptions to that, none of which is specifically in point, or at least was raised by facts as to make it in point in this case. Now, my lords, I make two submissions on this. First of all, I don't know if my learned friends are arguing the contrary, but I submit subsection 3 is plainly applying to criminal proceedings as well as to civil proceedings. Because it says all proceedings of every court, which must include criminal courts, And also, it would be bizarre, frankly, if this applied, if proceedings of a criminal court did not have to be held in public, or there was no equivalent rule. That would make no sense in the context of the statute. Secondly, I submit that the as this is a Charter of Fundamental Rights, you must look at this with a view to the purpose, the constitutional purpose behind this, which I submit is plainly for the benefit of A, the accused, and B, the public. And generally speaking, a hearing in open court is for the benefit of the accused and of the public, and certainly of the public. And therefore, I submit there should be no doubt that in saying, or you should have no hesitation in saying, that MACMA proceedings are covered by this, because they are plainly themselves proceedings, as they themselves, as the MACMA Act itself provides for. And I emphasize all proceedings of every court. My lords, I think that leaves me just with the question of discretion. And my lords, we deal with this at page 706 of the record. My lords, I don't propose to read them out, but it's just really for your note, because I propose to deal with the point relatively briefly, because I've taken you to the judge's judgment anyway. But paragraph 64 sets out our answers, but if I can put them in bullet form orally for the moment. First of all, the judge, bearing in mind the arguments which were raised before him, was entitled to say that a hearing in open court would end speculation. It would, in my submission. Of course, it might be that the questions would give rise to the issue of whether there should be, would give rise to the question of whether there was a privilege against self-incrimination. But subject to that, there was every reason to suppose these questions would put an end to speculation. If that speculation landed up being, well, these people did indeed take money from Trafigura, so be it. The second thing we say is this: the judge, it is said, failed to consider that the appellants themselves might one day face charges. But as I've said at the beginning, that point wasn't argued or put before the judge. Secondly, it's immaterial. Let us say, for the sake of argument, that there was some prejudice caused to one or more of the appellants on giving answers in open court. That would be a matter to be dealt with on an application for a stay of any subsequent prosecution, if appropriate. It would not be a sufficient reason for saying, well, we can't have these we can't have these proceedings, we can't have this hearing held in public in the first place. The third point is this: my learned friend says, the third point is this: the judge in my submission was quite correct in saying that the investigation was concerned with matters in the public domain. That is to say, Trafigura's contract with the state of Jamaica, and with payments said to be made to it by a political party. In my submission, that is plainly a relevant factor, and for the relevance of whether or not something's in the public domain, I don't propose to go to it, but if you look at the Bloomberg case at page 1451, paragraph 62 to 69, clearly it is a relevant factor. And then thirdly, I say that the judge was well aware of the point that the investigation had been instigated initially by Mr. Golding, and that the law had been made, or that the law had been changed ex post facto to enable the Netherlands to make the relevant request. And the reference for that is R1, page 20, MS page 29, paragraph 23. But my lords, as I've said, as he said in paragraph 33, there is no challenge. There was no challenge to the Netherlands' request seeking a hearing in court, and that request was made in accordance with MACMA's first schedule, and none of the appellants had not put forward any evidence to justify why it was, in fact, the hearing should not take place in public, save for the political objections. So in my respectful submission, there's no basis for interfering with the judge's exercise of his discretion. My Lords, finally, there's the question of the confidentiality of the letters of request. My Lords, I do object to that point being run now, because it wasn't raised below, and it raises questions on which evidence would have been appropriate. However, I do submit also it's hopeless. That is for the simple reason that the 9th supplementary letter specifically asked for the hearing to be done by the judge in court on oath. In my submission, that necessarily envisages the possibility, if not probability, that that hearing would take place in public. Therefore, there has been a waiver of any confidentiality in the request by the Netherlands, and likewise a waiver of any confidentiality in the request by the DPP, who is quite happy for the hearing to take place in public. My Lords, those are my submissions, unless there's anything which I haven't covered or which I should provide further assistance on.
Mr. Knox, I don't think there are any questions at the moment. The great form.
Thank you. I should say my Lords and my ladies. Do forgive me, but thank you, my Lord.
Thank you very much. Robinson.
It's a pleasure, my lords, my lady. I would like to begin where my friend began. The idea that the discretion to go to court under Section 20 exists not only where criminal proceedings are in place, but also where there's reasonable cause to believe an offence has been or is likely to be committed. Can you hear me, my lords, my lady?
Yes.
Yes.
We would say in response that there can be no such discretion, because as shown on the face of the instrument of designation of the central authority and the attached schedule, the DPP is not authorized to perform a function under Section 20 of bringing the taking of evidence into the court. So she is not allowed to bring proceedings or make any applications before the Supreme Court. She's not allowed to invoke the jurisdiction of the Supreme Court. Where she is allowed to invoke the jurisdiction of the Supreme Court, MACMA specifically says so, as in sections 27 but in section 20, there is no express authority for her to do so. All she can do is authorize the taking of evidence. Once appointed, the judge is acting outside of the jurisdiction of the Supreme Court. But not, as my learned friend said, as a glorified arbitrator. Rather, the judge is exercising a statutory function as an authority set up by the specific legislation. Submit, therefore, that section 16.3 of the Constitution that refers to every court is not in play. And the only possible part of section 16.3 that could be applied is in relation to other proceedings of other authorities, where civil rights and obligations are to be determined. I just that there are no civil rights or obligations being determined in this section 20 taking of evidence exercise. My learned friend then seems to say that under the provisions of MACMO, witnesses in Jamaica are somehow more compellable in relation to foreign investigations than they are in relation to local investigations. He repeatedly said that the judge would be able to ensure that the witnesses answer questions under pain of punishment. However, is there a specific sanction for not complying with the judge's order under section 20, subsection 3? Or for not answering questions, or indeed for not producing documents? In fact, the specific provision in MACMO is at section 21. And that, my lords, is at page 740, MS 740. Section 21 says, no person shall be compelled in relation to a request referred to in the said section 20 that we've been looking at, to give evidence or to produce documents or other articles which he could not be compelled to or produce criminal proceedings in Jamaica or in the relevant foreign state. In Jamaica, no person can be compelled to give evidence or produce documents on pain of punishment, as there is a general immunity possessed by all persons and bodies from being so compelled to answer questions posed by persons or bodies. And this is set out by, as he then was, the learned Justice Sykes, the Honorable Justice Sykes, in the Jerville Williams against Independent Commission of Police full court case. The point is also, and my lords and my lady, I would point out that that case is not before you. I can undertake to provide it if it would be of assistance.
Can I just ask, I assume that case is dealing with when the police ask you questions. I may be wrong, but by analogy with law, surely there's a power in criminal proceedings in court in Jamaica to require witnesses to come to court and give evidence and to answer questions.
Yes, and I was going to go there now to say that where that is the case, there are express provisions for that. So for instance, in the Coroner's Court, which my friend relies on, in the Coroner's Court Act, there is, there a parish court judge, to make the analogy more perfect, if I could set some context, the parish court judge there is in fact appointed to act as coroner. And the act then refers to him as coroner. He is not exercising his jurisdiction as a parish court judge. He is exercising his jurisdiction as a coroner. And when he holds an inquiry, he has the power to issue summonses to witnesses and to require the production of documents, but not as a parish court judge, as a coroner. And under that act, the coroner has a specific sanction available to him for failure, that he can exercise for failure to answer the questions asked or produce the documents requested without reasonable excuse. And there is, in fact, the sanction, I believe, is $4,000. I believe my Lord Hamblin has a question.
Does this argument feature in your written case?
Sorry, can't hear.
Does this argument you're advancing at the moment feature in your written case?
On the coroner's court, my Lord?
No, the general argument about there being no powers in Jamaica to compel the giving of evidence or production of documents.
No, it arises in response to my friend's case.
You didn't mention it during your opening of the appeal. He hasn't dealt.
I'm sorry, my Lord, I can't hear you.
You didn't raise it during your opening of the appeal, but he hasn't addressed. As I understand it, this is not an argument that you raised in writing or orally before now. Correct.
No, my Lord, in his case, in his oral arguments, he did speak to the fact that there is a discretion to go to court under Section 20. And it is that discretion that I am addressing, that there is in fact no such discretion.
But Section 21 seems to me a point against you, because it clearly recognises, doesn't it, Section 21 by implication, that the judge does have the powers of a court equivalent to those in criminal proceedings in Jamaica.
Yes.
Well, they don't. The judge of the Supreme Court under MACMO has no power to enforce the order made under Section 23. There is 20 subsection 3. There is no provision in MACMO for an order to be made in contempt of proceedings.
Well, why do you need Section 21 if the judge doesn't have those powers? There's no need to limit them. If the judge doesn't have powers to compel people to give evidence, there doesn't set any limit on his powers to compel people to give evidence. On your interpretation, Section 21 is completely unnecessary.
Right, but Section 21 is in relation to the giving of evidence or the production of documents, and not in relation to coming to court, attending court to give evidence. It's more it's more in relation to what's in the court. If the question is that you refuse to answer, is there a penalty for choosing not to answer? And under this legislation, there is no penalty. Under other legislation where the judge has similar powers in criminal proceedings, such as in the coroner's court, there are specific provisions for penalties where people do not answer without reasonable excuse. My Lady Dorian has a question.
Yes, in a situation where the judge is exercising the normal powers of the judge in hearing a criminal case, for example, surely the judge has, in that situation, leaving aside when a parish judge is acting as a coroner, in that situation, surely the court has an inherent power to make an order for a witness to answer a question, or indeed to treat a failure to do so either as prevarication or as contempt.
No, and this is why I undertook to provide this.
In the course of, say, in the course of a criminal trial, and a witness refuses to answer a question legitimately put in the course of the trial, are you saying that in that situation the judge would not have any power to deal with the matter?
The immunities in the case of Jerville Williams against Becombe which deal with essentially the right to silence, indicate that persons are not
Yes, but
compellable
we're
on
not
page.
talking about a question that might incriminate someone. We're talking about a general witness giving evidence, being asked a question which is not requiring them to incriminate themselves, and they refuse to answer the question. Are you telling us that the court has no power to do anything about that?
Yes, there is no jurisdiction in the court to compel a witness to assist the prosecution. The prosecution has a duty to make its case, and the Honourable Mr. Justice Sykes, as he then was, makes that point very clearly in the Williams against Indicom.
Well, one can understand that if it's a question of incriminating oneself. But beyond that, it's not that in relation to, say, an accused person, but a general witness who is not an accused person, who declines to assist by answering proper questions. Surely the court has the power to deal with such a situation.
No.
You're telling us, are you, that in a criminal trial in Jamaica, if a prosecution witness refuses to answer questions when called to give evidence, the court is powerless to do anything about that?
Yes, the first general immunity that applies is possessed by all persons and bodies, and it is from being compelled on pain of punishment to answer questions posed by anyone. So if I am summoned to court and I am asked a question and I choose not to answer it, that is the end of the matter. That I am a witness and I can either choose to say something or not to say something.
So you're saying that prosecution witnesses in Jamaica are not compellable in a criminal trial?
Yes.
Right. Well, I think we've got the submission. Lord Stevens has a question.
And does that also mean that they're not compellable where the evidence would completely exonerate the accused?
Yes, my lord. They would still be able to choose not to answer.
And so an innocent man would be wrongly convicted because of a lack of evidence during the course of the trial.
That is my understanding.
Thank you.
I do not practice at the criminal bar, but that's certainly my understanding of it, and it is from this case where Chief Justice Sykes, or Honourable Justice Sykes, as he then was, sets out that position, and I'd be happy to provide it.
Well, if no witness is compellable in a criminal trial in Jamaica, how does Section 21 operate? It means, doesn't it, that there's no power to compel any evidence under the Mutual Assistance Act?
And that is what we have been saying, my lord, that there is no compellability in this act. What Section 20 indicates is that the judge of the Supreme Court is set up as an evidence taker, and he can take the evidence on oath of each witness. He can cause it to be put in writing, certify that it was taken, and send it on to the central authority. That is really all.
I imagine you say if the witness refuses to take the oath, there's nothing the judge can do about it. That's your case, is it?
That is our case.
Judges in Jamaica have hardly any powers at all, really, if you're right.
Well, certainly not under this legislation.
Well, not at all, not in a criminal trial, you say. You tell us it's the same in a criminal trial.
Not against witnesses.
Well, if you're going to make such a startling submission, we'd expect to see some authority for it.
And I will provide it to the registry.
You say that Williams and the Independent Commissioner of Police is authority for this?
Yes.
I believe this was an authority that we had cited when the recent Indicom case was before the board.
Yes.
last year or the year before, but I don't recall it being cited as authority for this proposition. But we don't have it in the materials before us, so there it is.
We don't, unfortunately.
Well, there it is. Would be grateful if you would supply copies, please, promptly after the hearing.
I will, as soon as the hearing is over.
Thank you.
So for an example of where the judge does have the right to compel the evidence, there is section 22 of the Coroner's Court Act.
Sorry, section 22 of
the Coroner's Court Act, section 22 and 23, where there is a specific power.
I'm sorry, could you say which act again, please? The line is breaking up.
It's sections 22 and 23 of the Coroner's Act.
Thank you.
I also wish to point out that preliminary inquiries were abolished by the Committal Proceedings Act of 2013.
Lord Stevens has a question.
Is it correct that under preliminary inquiries, before they were abolished, witnesses' depositions were taken on oath in an open court?
That appears to be the position, my lord.
Thank you very much indeed. Okay.
But I do believe that there were statements would have been taken before in a private setting. My learned friend also made the point that in this case, everything was already in the public domain in any event. And that what was before the court and what was under consideration was clearly not confidential. And I would just like to point out that it certainly was in the public domain that these allegations had been made. Even some of the information about the banking documents, etc., all of that was in the public. However, as in the ZXC and Bloomberg case, it is not the information that is already public that is the subject of these proceedings. What these proceedings are in relation to is the further evidence which would come out of the answers to the questions asked by the Dutch authorities. And that certainly has not been in the public domain. My friend also, I found out sure I really understood exactly what was, I'm sorry.
We don't know what the further evidence is, and we have absolutely no way of gauging whether or not there's any expectation of privacy in relation to any of it, because nobody has told us what the further evidence is about which you have such concerns.
Indeed, it is not anything that has been spoken about or divulged in any way, shape, or form. And ZXC is authority for the fact that there is a reasonable expectation of privacy in relation to the investigation that is underway. And certainly the further evidence to be taken from these witnesses is part of that investigation. So yes, some information may be in the public domain, and we would say wrongly so, but to the extent that everything else in the investigation must now be public because of what happened previously, that does not at all follow. It shows that it can have reasonable expectation of privacy even after there has been publication of some parts of the investigation.
But Ms. Robinson, is there any basis for this in the evidence which was put before the courts below? Has this been set up at all?
Well, Well, we would say to that, my lord, that what is before this court is the appellant's request to have their evidence taken in private. And that in and of itself is a claim that starts with confidentiality as a concern. So to the extent that it would have been clear to Mr. Justice Campbell that these appellants were seeking privacy, and given that MACMA is new legislation and that the idea that these letters of request have confidentiality attached to them is all new to our system, then
Mr. Knox's objection to your being allowed to take the point at this stage, there are a number of objections, but the principal one, it seems, is that this is a point which should have been addressed in the evidence that was placed before the courts below, and it never was.
Yes, well, I'm not sure that there would have been evidence. I take the point that there may not have been a specific reference to confidentiality that attaches a letter of request. But we are here looking at an interpretation of Section 20 of MACMA in the context of the appellants asking for a private hearing. And I cannot think that confidentiality is not a relevant point given that context.
Lord Leggett has a question.
Are you suggesting, Mr. Robinson, that if you're a public official accused of taking a bribe, you have a reasonable expectation that evidence taken in relation to that will be kept secret and private?
Unless and until there is a charge, then yes, that is what ZXC says. Precisely because, as Lord Simon pointed out, there is the human characteristic of just not being able to understand the fundamental principle that you're innocent until proven guilty, and to think the worst, that where there's a smoking gun, there's smoke. So because these kinds of allegations can have such far-reaching effects on your reputation and your life generally, it is an expectation that you would have privacy unless and until you are in fact charged. And then, of course, the information is public.
Okay.
Thank you.
Obliged, my lord, my lady. I was about to say that I was not entirely sure what point was being made when there was a reference to paragraph 1 of my written case as being an incorrect reference to.
I made that observation, Ms. Robinson, and as I read paragraph 1, it says, I have it here. Paragraph 1, it says, this is an appeal as of right from concurrent decisions of the Supreme Court and the Court of Appeal. And I was going to invite you to respond in relation to that, because it's, as presently advised, it seems to me that this is an appeal from the Court of Appeal and not from the Supreme Court. And indeed that there was an attempt to appeal from the Supreme Court, but that was abandoned.
Okay, so my reference here was in relation to the concurrent decisions on the subject matter of this appeal, which is whether or not the hearing would be in public. And there was a Supreme Court decision of Mr. Justice Campbell, which was upheld by the Court of Appeal, the decision of Mr. Justice Morrison. So those are the two concurrent decisions that I'm referring to. Obviously, this appeal is from the Court of Appeal, but I was merely making the point that the Court of Appeal had upheld the learned judge below.
Oh, I see. So you're not referring there to the decision of the full body of the Supreme Court.
No.
Right. Thank you for that.
That constitutional claim, as has been said, was appealed, and the appeal was withdrawn.
Yes, that's what I thought. Thank you very much for clarifying that misunderstanding. I'm grateful.
Thank you. Thank you, my lord. And so turning then to the Constitutional Court decision, which my friend has spent a long time on, we would generally say that the arguments there were necessarily constrained to constitutional arguments. And so to the extent that anything was raised in that case that has been raised in this case, there are completely different considerations, because in the constitutional case, the court was fixed on whether or not there were breaches of specific provisions of the Constitution. Of course, that does not arise here, and it is no part of our argument here that there is any constitutional breach in terms of the Charter of Fundamental Rights and Freedoms in relation to the order of Mr. Justice Campbell, and Mr. Justice Anderson, which were under review by that court. The only aspect of the Constitution that arises on this claim is the open justice principle, which Mr. Justice Campbell relied on in his decision. So to the extent, for instance, that politics was dealt with by the Constitutional Court, and my friend has said that it was dismissed as not having any basis, we would say that that is because the politics had no nexus with the specific constitutional provisions that they were there arguing. That does not mean that in the context of this case, the political motivation is not relevant. I believe my Lord Stevens has a question.
I thought that you were arguing that the Constitution didn't include these types of proceedings. And that was a point that has already been decided in the constitutional case. So aren't you bound by that outcome?
No. Section 16(3) and the application of the open justice principle was not adjudicated upon in the Constitutional Court. The particular reference was in, it was argued under whether or not there was a breach of the claimant's right to due process and a fair hearing. And she did, the learned judge writing the opinion, if I may just have a moment, my lords and my lady, to find the section.
Well, can I put a...
Yes, there was oh, I'm sorry.
I just thought that the Constitutional Court said this was a proceeding within section 16(3).
Well, insofar as they may have said that, my lord, our position would be that it was per incuriam, because there was no argument before the court in relation to what section 20 in fact meant. And I think that it is there at section, at paragraph 228. Right, and so this goes to what I was saying, that it really, this is in the context of the constitutional claim, because she speaks there about fundamentally there is no constitutional right to a hearing in camera. And so certainly, nobody would say that there could be, that anybody could find fault with that, but that is not what is at issue in this proceeding. And certainly I believe my friend, in response to the questions, was saying that it is not open for us to be raising this point now. It is just that he would suggest that the reasoning of the judge in the Constitutional Court should be followed. In relation to the point about treaty provisions raised by friend, it seemed to me he was trying to raise them to say that in the construction of MACMO, the treaty provisions ought to be taken into account. And I would just point out that Jamaica is a dualist state in that it has to enact domestic legislation to give effect to international obligations. And so it really is the enacting legislation that governs what the country has signed up for.
Does legislation not have to be interpreted in the light of the convention to which it gives effect?
Well, certainly, and the point is taken, because certainly in this case there is no, there really is no distinction between what is provided for in Article 18 and what is in MACMO, save that it cannot be that a court is what envisioned by Section 20 when in the order designating the DPP as a central authority, she has no power to refer the matter to a court. That really ought to be the end of it, and I don't see how reference to an international treaty can get around the fact that she doesn't have that authority under the order. Furthermore, sections 39 and 40 of the Judicature Supreme Court Act are very clear about when a single judge of the Supreme Court may exercise in court or in chambers, and this is at MS 987. The powers of a single judge are set out. It says a single judge of the Supreme Court, which is what Mr. Justice Campbell would have been if the interpretation my friends ask for is correct. It says a single judge of the Supreme Court may exercise in court or in chambers any part of the jurisdiction of the court which before the passing of this act might have been exercised in the like manner, or which may be directed or authorized to be so exercised by rules of court to be made under this act. In such cases, a judge sitting in court shall be deemed to constitute a court. Now, clearly, none of that applies to Section 20 of MACMO. In Section 40, there is further provision made for a judge of the Supreme Court to constitute a court of the Supreme Court where he is holding a circuit court or sitting as an election court. So there is no provision in the statute that gives rise to the jurisdiction of the Supreme Court to allow for a Section 20 evidence taking process to be part of the jurisdiction of the Supreme Court. Taken together with the fact that there is no authority given to the DPP to take the matter to court, it seems without there really can be no doubt that Section 20 is not a reference to a court proceeding. It can only be a reference to a proceeding that is authorized by statute, or for the purposes of Section 16.3, an authority. So my friend also indicated that the state that there should be, if there was a complaint about the public taking of the evidence and any question that prejudiced the defense of these appellants in the event that they were ever charged with offenses. His comment was that that would be an issue for a stay of execution of those proceedings. And that is precisely the point that these appellants are making, that a stay of execution of those proceedings would be inimical to the administration of justice in Jamaica. And so why create a problem that you do not have in relation to foreign investigations when you know that it is, if these things are true, it is likely to result in an investigation and proceedings in Jamaica, which would need to rely on that evidence being confidential. Right? That evidence would be prejudiced if it's not confidential. Why would we work on the back end to deal with it when, if we are really focused on the administration of justice and on enforcement of the rights and obligations of people, enforcement of the rule of law, then those things ought to have been foremost in the judge's mind, not having the taking of evidence at an investigative stage in public when that is not something that would ordinarily occur. I was just going to say, in response to the section 24 of MACMO, which my friend raised, and yes, it is true, as my lord had pointed out earlier, that there is this presumption of non-confidentiality. I would refer to the guidelines issued by the respondent herself, which are in the bundle, and I'm sorry if I can just find they are at MS 1059, and MS 1059 you will see that this is the third edition of these guidelines, which were published in September 2019. I have tried and not succeeded in finding out when the first edition was published, but I'm sure that the respondent would be able to advise the court. But the point of confidentiality is raised at MS 1069, and the position put forward by the appellants is accepted there by the DPP, that it is customary in mutual legal assistance that Jamaica considers every request for assistance to be confidential. So that does seem to be the starting point. And we certainly would say that where, for instance, in the 9th letter of request, there is that request for the evidence to be taken by a judge at a hearing in court. Again, we would say that this has to be subject to section 19 of MACMO, which is, it has to be in compliance with Jamaican law and procedure. We have made the analogies with our law and procedure in relation to investigative stages of proceedings, which is what we say section 20 is, but it is not a court. And so for those reasons, we would say that the request in this 9th letter of request cannot oust the curtailed situation created by section 19 of MACMO. Section 19 of MACMO must be upheld, and it must be upheld in the context of section 20 not occurring before a court. And so, my lords, I would just close by saying that in the judgment that granted leave to this court, my Lady Phillips was concerned with the fact that there, and in fact it is in of Mr. Jasmar in the Court of Appeal. You know, it really is unfortunate that there are no regulations to maximum that would guide the proceedings in Jamaica. And it does seem clear that what has happened here is that there's been a bit of making it up as we go along, certainly in relation to a fixed date claim form in civil proceedings. And so it is hoped that this matter will be looked at closely by and the issue particularly of confidentiality will be looked at closely, because it is something that arises on the fact of them asking for a private hearing and arises on the fact that the DPP's guidance says that letters of request will be treated confidentiality. In those circumstances, it cannot be helpful for there to be a decision that Section 16.3 ought to apply, and there ought to be this open public taking of evidence, which ultimately can only prejudice that evidence for the purposes not only of the foreign proceeding, which is paramount because this entire act is for the purpose of the foreign state, but also in relation to the administration of justice locally in this jurisdiction.
Thank you, Ms. Robinson. Do you think there are any questions? There are not. So that completes the submissions. Ms. Robinson, Mr. Knox, we're grateful to you and those instructing you for your submissions and for the preparation of the case. The board will now take time to consider the advice which it will tender to Her Majesty. Hearing is now adjourned.